This is a tutorial on the cancellation of contract. This is Form CC. The full title is Cancellation of Contract, Disposition of Deposit, and Cancellation of Escrow. It was revised at least once in 2023. Here we are in March of 2024. This is the latest version of the form. Now we have a tutorial already on the channel, but that was done a couple years ago, and someone brought to my attention that it's dated and that there's a new form. So here we are looking at it. It's 2 pages. And I just did a video all about how and when each party can cancel a transaction. Now this is the form that will be used, so let's jump into it. Now it starts here by saying this is part of the purchase agreement by default. We put the date of the purchase agreement, top left corner of page 1 of the purchase agreement, not the date that we're drafting this form. Property address, names of the parties, pretty straightforward. Now, one of the new changes is that there's this advisory section that has expanded. And I won't read this whole thing, that would be boring, but I will go through and just skim it because this is actually fairly helpful. Now, the first paragraph is about the party that's canceling acting in good faith, which is important because there's penalties if one party is not acting in good faith. Now, the party canceling the agreement, not the agent, needs to determine if a cancellation right applies. Now, an agent is going to point their buyer out as to their ability in the purchase agreement to cancel, namely somewhere, here's a purchase agreement, somewhere in paragraph 14, if I can find it. So paragraph 14, rights to cancel, and you can go on and skim through here. But it's up to the party canceling to verify that they do have a right to cancel because no party can just willy-nilly cancel. There must be a provision that allows effectively a loophole to cancel the transaction because canceling improperly is breach of contract. If there's an open escrow, escrow will need mutual agreement and instructions signed by both parties. When escrow is going to release a deposit, they must have instructions signed by both parties. And then parties are advised to consult with a qualified real estate attorney regarding potential damage and remedies. This appears to be a no-brainer. People will look at this and think, well, of course. But here's the problem. Agents often act as an illegitimate attorney or legal representative. I see it all the time. If a party cancels a transaction and it's canceled, the agent's job is done. That's it. There's no negotiating a portion of the deposit for one party or the other. There's no negotiating a settlement or making legal threats of mediation or suing. Same with if a property records or closes escrow, the agent, their job finishes. They're done. They don't do anything else. But agents, they're so used to to assisting and being a fixer for their client throughout the entire process that they start negotiating with the other party. That's acting as an illegitimate legal representative. An agent cannot do that, and I see it all the time. I won't belabor the point, but if there's a cancellation or if there's a recording, the agent's job is done. That's it. Any other thing, at that point, refer your client to an attorney, your former client. How about that? Your former client to an attorney. All right, now this form is 2 forms in one. Now the bottom half of page 1, this is the cancellation. This is all that needs to be done in order to cancel a contract. Page 2 is all about what to do with the deposit that's sitting in escrow, the earnest money deposit. So page 1, we'll start here. So cancellation of contract. Now, sometimes I see these forms signed by the party canceling, and I'll hear from an agent, hey, the other party's not signing. They're not signing the cancellation. Well, they don't need to. They don't need to. The agent's misunderstanding. The only time you need a countersignature from the other party is down here for the release of deposit because escrow needs both parties to sign. For cancellation, that's a unilateral action. One party cancels, and then they deliver this cancellation to the other party, and the other party can't do anything about it. It's over. It's done. One party does it. All right. One party cancellation. Now, simply check the box of which party is canceling. Okay, then we move on. Most commonly, you'll see this, as permitted by the good faith exercise of paragraph, and now we jump back to the RPA. Okay, buyer right to cancel. So we have paragraph 14D, buyer right to cancel. And you can get even more specific if you want. we jump back here, we write in, paragraph 14. You just write that in, paragraph 14. You could write that in, sign this, and you're done. If a buyer checks this box, buyer writes paragraph and writes the number 14 here, checks this box, signs this, dates it, sends it to the listing agent, it's over. That's it. The transaction is done. The only looming issue is how to disperse the deposit on page 2, and we'll get to that. Now, if a seller, let's say a seller, so this is the most common, a buyer's backing out probably because they didn't get the loan they wanted to, or an inspection came back and they don't like what they saw. That's the most common. Buyer, check this box, write the paragraph, sign it, move on. Hey, we're in the inspection period. Sorry, wish it worked out, but we're backing out. Okay? Now, sometimes a seller, it has to enforce, and this is, please watch my video all about cancellations. It'll explain, but sometimes a seller has to send a notice to perform. Buyer failed to remove contingencies or did an action, asked or requested in the notice to perform. So the seller will check this box. So seller, check this box here. The seller sent a notice to perform. Buyer didn't perform. Now the seller's canceling. So seller, number 2, and then the seller signs and it's over. Same idea where if a buyer sent a notice to perform to the seller, check this box. Buyer, check this box, sent the seller a notice to perform. Seller didn't perform, so checks this box on 3, A3, and then signs. It's done. Once it's delivered to the other party, the transaction is canceled. It's over. Now, there's also this demand to close. Let's say one of the parties is not closing in time. A demand to close form has been sent. There's a 3-day waiting period with the demand to close. You check this box down here. So you'd start with the party that's canceling. Then you check the demand to close. And then you sign it and you send it and it's over. See how simple this form is? It's so simple. I see people write this stuff in here and you don't need another. You really don't. I mean, people write stuff, they get angry. Well, this person did this and they give like a narrative. You don't need to do that. Virtually pointless to have other. All right. What's B? Proposed mutual cancellation. Now, all things considered, even though there are provisions in the contract, in the RPA, that allow one party to cancel, both parties could be contractually obligated. There could be no escape clause in the RPA. All contingencies could be removed. But what if both parties say, you know what, this just isn't working out for me, and the other party agrees, and they both agree with that statement? Well, they can just agree to both walk away, and that's what happens here. Does that happen often? No, but there's a provision for it. That's mutual cancellation. They check this box. And so if that's the case, if there's a mutual cancellation, or at least one party's proposing, because so this is when you have a reason in the purchase agreement to back out. This is when you don't have a reason and you're trying to propose a mutual cancellation. Hey, can we please cancel? Is that going to happen often? No, but it's here for it. All right, so signature by the party canceling the contract, and that's it. Now, because the deposit works hand in hand with the cancellation, we have this whole disposition of deposit and cancellation of escrow. Because when this is signed by both parties, this is going to act as instructions to the escrow company. So you'll write in the escrow number, escrow company name. Now, the most common thing you see, especially when this is filled out by a buyer's agent, that has, let's say, a buyer's agent up here did buyers canceling because of inspection period or loan contingency period or whatever. You go down here and you're going to check this box. Seller authorizes release of buyer's deposit to buyer. Now, of course, less buyer's fees and costs already incurred or agreed to in the contract. This must always be. Now, there used to be an other line, and agents would write release of full deposit. All right, well, that's what this is. You just have to understand that if the buyer billed escrow for an inspection and escrow has an invoice, the buyer, that needs to be deducted from the buyer's earnest money deposit. If there wasn't anything that the buyer already agreed to in escrow, then you don't have to worry about this. I mean, this is a full release of the buyer's deposit. And if there's any deduction, well, the buyer already agreed to it. So you don't have to write, no, the buyer gets 100% no matter what, no matter what. Doesn't make sense. This is a full release of the deposit, C1. There's C2, and that's an or. Buyer authorizes the release of buyer's deposit to the seller. Does this happen often? No. I've seen it happen, but it doesn't happen. This is buyer saying, here you go. Give my deposit to the seller. Thank you. Not very common. It's usually C1. Or C3, release of X number of dollars to the seller. Now, I've seen this too. This is, let's say the buyer has removed all contingencies, still wants out. They negotiate where the seller keeps 50% of the earnest money deposit. Well, this is a situation where a portion of that deposit can be retained by the seller, and they divide it up. And then 4, there's no deposit in escrow. Usually if there's no deposit in escrow, no one's even bothering with this, but it's good that you have it here in case. And then this partial release and reservation of rights, this will rarely be used, rarely. Again, 2C1 is the most common usage of this disposition of deposit form. Partial release and reservation of rights, so naming the escrow number, and they're basically saying, hey, escrow, or maybe a law firm, they can hold the deposit until they duke it out with a judicial decision or arbitration award. Why there is a no deposit in escrow box with this, this will never be used. This, in conjunction with this, will almost certainly never be used. This is very uncommon because even when this happens, no one even bothers writing it out. The deposit just stays in escrow. And usually escrow is like, hey, I have your deposit. I don't want to hold on to this, because an escrow is reconciling their trust account and they have to account for why they have money sitting in there indefinitely. Anyway, if you have any questions, leave a comment. Happy to explain. Both parties need to sign the disposition of deposit because escrow can't release it until both parties agree. That's it. Now, one last point, again, I may have said this earlier, but you could send the cancellation and leave page 2 blank, and it still cancels the contract. People act like these 2 signatures here have anything to do with this. No, in fact, they write this now because C.A.R knows what I just told you. And so they wrote this out. They do these things to make it just turnkey easy for agents. Solely for cancellation of contract, proceed to page 2 for disposition of deposit and cancellation. They even tell you, separate. Because I'm sure that C.A.R Legal and whomever have gotten 5 million phone calls of people saying, the other party won't sign my cancellation. And then C.A.R Legal has to say, that's not a cancellation that they're countersigning. That's the disposition of deposit. Totally different. Only one party cancels. That's it. All right. Please leave a comment. Thanks for watching.